This is the first time that we've ever done this on a live streaming program, so hopefully there won't be any technical glitches, but if so, please bear with us. And thank you to Roseanne Hoover from the Brooklyn Bar Association Referral Service, and to Jen for making this happen. And most of all, thank you to Jimmy Lathrop, who will be presenting here tonight. So the Brooklyn Bar Association Foundation Law Committee puts on several programs a year. It's nice to see some of the faces back. Once you're on the list, you're forever on the list, unless if you send us an email telling us to please take you off, which happens sometimes to people that somehow get on the list and don't want to be. But all of these programs are free to the public. I see a number of attorneys and a couple of judges that are here tonight. I always say we have about half of the audience usually is the legal profession, but this is really meant for all of your colleagues to know and to pass around to your neighbors, your friends, your community. Anybody, while it is the Brooklyn Bar, if you live in Queens, we're not going to throw you out. Please come, spread the word more than anything, because it's really hard to get legal advice from practitioners in a field when it's not a program that is something. For example, I'm an eligible attorney. I give eligible programs, but this is something that we put on with different topics through the year. And it's hard to just find advice out there, practitioners who are looking not to give CLEs to the legal community, but to give forums for the public. And that's what the Foundation Law Committee is. It's a public service that the Brooklyn Bar does for the public. And again, please spread the word on any of our programs. We have coming up a program on March 26th, Consumer Debt and Bankruptcy. This program we put on every year, I think 7 or 8 years. Rich Class will be doing it this year, as he has in several years in the past. And on April 30th, we will be doing a program on Know Your Rights for criminal law. And that's going to be put on by a presenter from the Brooklyn Defender Services. And that's the first time we're going to have the Brooklyn Defenders here. If there also is a program that you feel would be of great interest to the public, not just to you, but something that would speak to you and your community, or something that should be put on, please contact me. I'm Fern Finkel, ffinkel@ffelderlaw.com, or you can let Roseanne from the Brooklyn Bar know. All of you should have my email. It's again, ffinkel@ffelderlaw.com. And I'll consider, I'm not going to promise you I'm going to put on a program, but certainly if there seems to be enough interest in a hot topic that would be something of value to the public, that's something that we have the ability to do. And we've tried on different programs through the years. Some hit, and one time we had 3 people here for a whole program with 3 presenters, so that one was not one that we repeat. Okay, this is also was one that we put on several times before, and Jimmy has presented for us several times before. So without any further ado, we're going to go from now straight through to 7:30. We're not going to take a break, but the last 10 minutes, Jimmy's going to try to take questions. Jimmy has been, we had the discussion, he's going to try to go through the program, because if we stop for a particular question, then his presentation that he has prepared he will not get to give the information. It's going to be more focused on one person. The question might be germane to others, but still, then we're going to wait for the last 10 to 15 minutes for that. And Jimmy also, I could tell you, will stay afterwards to answer questions that you may have. So feel free to stick around afterwards, and within reason, he'll be able to do that. So Jamie Lathrop is a graduate of Bates College at Brooklyn Law School. He worked for a while for the Brooklyn Bar Association, has done extensive pro bono work, including for the Eastern District, New York, the pro bono panel on the Civil Court of the City of New York, for the Volunteer Lawyers Project in the Resource Center. His credentials go on, but what Jimmy is known for really is his expertise, his ability to handle complex matters in housing court, landlord, tenant court, co-ops and condos, and a number of other fields. He has a wonderful office and a real ability to listen and to really, his ear is to the ground. He knows what is happening in this field in particular. So I give you Jimmy Lathrop, and I hope you enjoy the presentation.
Thanks so much, Fern, for such a glowing recommendation. It's always an honor to be here speaking with the Foundation Law Committee, which is a very important committee that we have here in the Brooklyn Bar Association, of which I'm happy to have been a trustee for the last 6 years. Fern has tireless work with bringing these lectures to the public, which gives people an opportunity to get legal information, and sometimes, avoid the hassle of having to take a trip out to an attorney's office and pay a consultation fee. And it's a wonderful concept where we're allowed to impart legal information, not always legal advice, a little disclaimer there, right? But that we can give you all some, legal information that may help you in a particular area of law. And Ms. Nickel has been tireless in her ability to bring forward these very, very valuable lectures, I might add. Not just that the fact that the information I'm imparting you today, of course, is valuable, but I mean on other topics as well. I would also like to take a moment to thank the members of the judiciary who are here tonight, the Honorable Maria S. Hufscher, retired of the Justice of the Supreme Court, as well as Gary S. Martone, who happens to be a judge of the Housing Court here in Kings County, and we're very thankful to have both of them here. If I could just take a minute to also give a little recognition to the Brooklyn Bar Association Lawyer Referral Service, who is sponsoring this event and live streaming it on Facebook as well, entering the 21st century, right? We have Roseanne Hebert, who's the Executive Director of the Brooklyn Bar Association Lawyer Referral Service, which is one of a kind here in this country. And what I mean by that is it's a nonprofit legal services organization which allows people to take referrals to other attorneys. If you're not familiar with the Lawyer Referral Service, it is an organization which screens attorneys for experience and expertise. Every attorney is interviewed by a member of the LRS, and after the initial investigation every attorney has to have a $1 million malpractice policy, which means, if they, in order to provide some backing for the advice that they're giving the representation, it's among the most successful legal service organizations, referral services. Ms. Hager has been given numerous commendations for her work with serving a very large community of litigants here in Kings County, people who need the services of an attorney. And there's a $25 consultation fee for half an hour. And the telephone number for this organization is 718-624-0843. When you call, one of the staff will take a moment to go through your issue on the telephone, and then they'll give you the name of an attorney who's been pre-screened by the committee, who indeed has a duly licensed attorney who has a malpractice policy, and you'll have a half-hour consultation with them in order to discuss your issue. And if everything works out well, you may have an advocate who will be standing next to you in court or resolving your situation out of court. And so I highly recommend that you use the BBA LRS. There's not a lot that we have that's comparable to that in the United States, let alone here locally in New York. So if you got it, use it. Right? Sure, the telephone number again for the Brooklyn Bar Association Lawyer Referral Service is 718-624-0843.
There are cards in the back of the room.
There are cards that are in the back of the room that you can take on your way out. You don't need to go to the Bar Association. All you need to do is just call, and they will give you the name, the address, and telephone number of an attorney who will give a consultation. And when you call them, you'll be able to, you'll be able to call the attorney directly. We also have these lovely pens that are also very useful for you. So when you are, walking about your day and you're having a trip in that pothole, steady yourself and then call your attorney. Okay?
Which is on the pen.
So just to give you a little bit of background about my practice, I have a small shop in Park Slope. I have a couple of attorneys who work with me, and our practice concentrates on litigation with some transactional work. We do mainly real estate. We also do some criminal cases. We do some matrimonial cases, business litigation. I have also the pleasure to be on Part 36, which is the approved list for attorneys who are able to appear on behalf of guardians and for people who have been adjudged incapacitated under Article 81. So that means that when we have somebody who's vulnerable and there's an guardian appointed for them. The court sometimes appoints, an attorney to represent their interests, either in some litigation in the Supreme Court, but generally in my case, it's usually in housing court situations where, we have landlords who are sensing an opportunity to, deal with somebody who may not all be there, begins litigation against a tenant, or in certain cases where you have a landlord who's incapacitated, who has to manage the affairs of his building, will then hire an attorney then to, get their business together and straight. So it's a wonderful opportunity. It's a huge vote of approval that we have judges who are elected and that they have said, I'll let Jimmy in his office handle it. I have the confidence that he's going to be able to resolve the issue and that he'll be able to do it in a professional way, and that my name's not going to be in the New York Post. This is something that he did. It's huge, big improvement. So I just want to take a moment to, the last plug I have before I start to get into the substantive aspect of this is there may be some attorneys who are here. I mentioned before that I'm a trustee of the Brooklyn Bar Association. I'm also happy to be the vice chair of the membership. I can say without any reservation that my life changed dramatically for the better when I became involved with the Brooklyn Bar Association. I'm a member of several bar associations and also the, without providing any competing information, and just like a parent who says they love all their children equally, I love the Brooklyn Bar the best. They're my favorite child. And so we have a wonderful community of very down-to-earth, kind, loving, intelligent, mature, and very, very cooperative and generous members of the Bar Association. It's refreshing to get together with other professionals who are down-to-earth, who we have an opportunity to interview. So I would suggest that, if you have an opportunity to join the Bar Association, you should definitely do it. And I also want to take a moment to thank Judge Gloria Dabry of the Supreme Court for being with us this evening. It's also another vote of confidence in my ability to impart some legal information to the public. So without further ado, I'd like to speak on the topic of cooperative apartments here in New York City, right? Now, you may be on either side of the fence, whether you're for them or against them, but they're here and they're not going anywhere. There's a wealth of information regarding cooperative apartments that I was able to find on the internet and coming here, knowing that I'd be live streamed and fact checked. So I had an opportunity to draw, and I was actually kind of surprised at the amount of very helpful, relevant information which is made available to the general public that actually pops up on the first page of Google. So I'm going to be referring to these throughout the lecture, and start broadly and then be able to go into the more specifics of this. And one of the things I'd like to use in the beginning is a little information that we have. I'm going to use first a little discussion from the former judge of the Housing Board, who has since moved on to the Supreme Court, Gerald Leibowitz, who, after he left the Supreme Court, became an acting justice of the Supreme Court. After he left the Housing Court, became an acting justice of the Supreme Court and worked in the integrated housing part in Manhattan. The integrated housing part deals with tenants who have an Article 81 case where they've been judged incapacitated. And by that I mean, just to give a little more background, there's been a finding that a person doesn't understand the consequences of their actions, and as a result of not understanding the consequences of their actions or unable to change the consequences of their actions, they're placed in jeopardy. And then, a petition is filed in the Supreme Court, which suggests that this person needs to have someone to look after their interests. We have somebody who's appointed. And so when the case has been transferred out of the housing court into the integrated part, there's sort of a holistic way where we try to, instead of having two separate proceedings where we have a housing court case moving forward and a guardianship case moving forward, try to combine the two to find out what's in the best interest of the ward while balancing the needs of the landlord and petitioner. And we were very, very fortunate. Judge Leibowitz writes for the New York State Bar Association's real estate journal that we have, of course, in the section. And he wrote a wonderful background on cooperative law, which I brought with me today. And I'm going to use that sort of as the roux to this gumbo that I'm going to be serving each day. I'm going to throw in my own little shrimp and monkfish from my own personal practice, that'll spice it up a little bit. but, make no mistake about it, Judge Leibowitz is very kind enough to do a lot of the heavy lifting for me to provide a basis. So without any further ado, we get into it. Cooperatives are very unique ownership regimes where different property interests are created. We have a cooperative corporation which buys a building in fee simple, and the cooperative is actually the owner. And then the shareholders purchase the cooperative shares, which are then personal property. Okay, and the third is created when the corporation enters into long-term leases, called proprietary leases, with those shareholders entitling each shareholder to occupy a particular unit. And cooperative corporations, which own the building, they can be formed in the New York Statement of the New York Business Corporation Law, non-profit corporation law, or the cooperative corporation law. And they have to choose the name, they have to file articles of incorporation, and draft bylaws. The articles of incorporations are tailored for cooperatives, and because cooperatives are formed under the Business Corporations Law, they have to include their articles of incorporation with any provision. It has to be consistent with state law. Right? And these are all things that have to be out in the open. They have to be visible to shareholders and to the Attorney General, who regulates the day-to-day activities of cooperatives, to make sure that they are following numerous laws, which include but are not limited to fair housing regulations, business corporation law regarding the duties of the board and shareholders, Department of Taxation and Finance, anything having to do with housing preservation and development, as well as the division of housing and community renewal, in limited situations where we have what's called non-eviction plans, and we have tenants who are choosing to remain in these buildings as opposed to purchasing a unit as a shareholder. Many cooperatives include in their articles of incorporation the powers to manage a cooperative, to buy property and buildings in fee simple, to lease the apartments, mortgage buildings. Now, something that's important for you all to understand when you're dealing with a cooperative is that they are bound by these rules. Right? Much like a Rubik's Cube, there's only so many things that you can do with a cooperative unless it's included in the offering plan, the articles of incorporation, and the bylaws. Those are essentially the framework for where you can navigate the maze of dealing with a cooperative, whether you're on a board or whether you're a shareholder. And in order, if a cooperative renter or a shareholder has a grievance against the cooperative, we use what's called a derivative shareholder lawsuit, which is commenced in the Supreme Court in order to get the type of relief that they need. As with all corporations, cooperative corporations owe their shareholders fiduciary duties. And if these responsibilities sometimes conflict with duties the corporation, acting as landlord, owes to a proprietary lessee. Right? So what that means is sometimes the cooperative has to choose the needs of the many over the needs of the few. Okay? And to get even more simple, in my practice, about 5 to 10% of my practice every year involves representing people who, are shareholders in the cooperative, and who either my clients or the board themselves are exceedingly uncooperative people. And then they need me to see if we can all get together and cooperate and bring harmony into this place. Yep. Shareholders don't own a unit in fee simple. It makes it different than as if you're owning a condominium unit where you own your unit as a standalone unit in the building, and you also are then entitled to a percentage of the common area as a unit owner in a condominium.
Sorry.
Instead of actually owning your unit outright, what you have instead is you own shares of the cooperative, right? And then the cooperative corporation then issues you a proprietary lease, which is pertinent to that shareholder, to those shares. So by owning shares, you then have a right to reside in the premises as a lease. This is a very important distinction. Okay? I'm going to get into this later, but I just want to mention to you as an outset in the very beginning, because it's a common problem that we have all the time. Right? It's very important for you to consider this. Just take a step back. In New York, because of the financial crisis that took place in 2008, 2009, we had a lot of legislation which was to provide homeowners with consumer protections if they were in default. You know, we did a lot of work in the legislature and in the judicial level in order to provide homeowners, people who own the property outright, right, to work out terms with the lender. You know, based on the assumption that it's always better to see if you can work out the situation with a lender and a homeowner without having to result in an auction, right? So here in New York, we have a complicated process, which has resulted in a very large backlog of cases where, you know, banks essentially make a complaint which say the homeowner or apartment owner had a promise to pay, we lent them money, we made a demand for that money, they didn't pay that money, and now we're accelerating the note, and we want all that money at once. We want the court to put on their equitable hat and transform a referee with the power to sign a deed as though the owner of the unit was signing this deed after an auction. So we can sell the property to satisfy this debt. And these types of cases are what we call an action in equity. Right? And what that means is there's two types of lawsuits where we have actions in law and actions in equity. An action in law is when someone borrows $10,000, $10,000 is not paid back, and the lender says, well, I would like a judgment of $10,000 so I can garnish their wages, seize their bank account, seize their livestock, you know, and put this against them at 9% interest, which is a fairly simple act to do. But an action in equity, the court is made to put on their magic cloak and their wizard cap and infuse the power of the state with a third party, a referee, to do something. Once you start invoking the power of equity in the court to do something, a whole bunch of other concerns then come into play. The balance of equities, right? Is this the right thing to do? Because we're using this judicial magic, right, to go through a goal. Right? And this all happens on the people who own homes. And this is why the standard track to foreclosure here in Brooklyn is 784 days. That means from the time a complaint is served, right, all the way to the very end when auction, the average time is 784 days. You know, if you're interested in the law of averages, you would say, hey, Jimmy, that's pretty remarkable. Right? That means that some cases take shorter than that, and some cases take longer than that. Yes, they do. And I have many cases that I've been working on for several years with homeowners trying to work something out with their exhausting lenders. We have certain cases sometimes which go straight to judgment and no one does anything. Maybe the property is vacant, maybe it's been abandoned. But the average time is 784 days. Now, all that being said, all of that does not apply to cooperatives. Right? And this is important to understand. A cooperative is personal property. When you're buying your cooperative, you're taking a loan out from it, the bank places a security interest on the shares themselves, the pieces of paper, the stock certificates. When you go to the closing and you're buying that cooperative unit, there will be a person, a paralegal, or a messenger from the bank representing the old loan. And they will have those shares in a satchel. And when the check is given to pay those loans off, that person will reach into the satchel and hand over those shares to the new bank, which will then place those shares and put them in their pocket like a hostage. It's really remarkable. The shares themselves have power. And these corporations spend a lot of money storing these shares. Many financial institutions use Iron Mountain. Iron Mountain used to be a depository for uranium deposits. And then during the SALT II treaties, where Reagan and Gorbachev got rid of all those nuclear weapons, they had these big secure facilities in the Dakotas and no one knew what to do with them. But they said, hey, let's fill it up with all these pieces of paper that these lawyers make. And it was brilliant. And they make a lot of money. The guy I went to with college, he's a general counsel. He's very comfortably handling all these little pieces of paper that we have around. It's really remarkable. I could talk about that for an hour later, but Bernard would get very angry with me if I did some of this stuff. What I'm going to say instead is these pieces of paper, they carry a lot of weight, right? And it's an action in person. And they're covered by the UCC code, the the Uniform Commercial Code, right, which New York has adopted most, not all of it, but most. And despite all the homeowner protections that you get when you get notices from the bank saying you could lose your house in foreclosure, you have 30 days to respond to this and pay some central, some certain, and if you don't, someone can take your house because of foreclosure. You have the right to go to a courthouse and present any defenses. If you pay your money, it'll be just as though you were back in the position that you were. All that's out the window. If you don't pay your loan as a co-op owner, the bank will send you a notice. Hey, did you forget us? You owe us some money. You don't pay that money by a certain amount of time, bad things are going to happen. And I don't even need to get into it. Just do it. And you get bills, you're going through some problems. You may not understand the significance of it. It's the next letter you'll get from a law firm, which says, hey, your shares are going to be auctioned on the steps of the courthouse on Thursday, 2 o'clock. You may want to be there. At which time you're going to call the Brooklyn Bar Association Lawyer Referral Service at 718-624-0843 and say, what? And ask for an attorney, right? And what that attorney's going to have to do is make up an order to show cause and run to the courthouse and request a stay. It's very, very, very different, right? So the lag time is very shorter. So it's very, very important that you have a good relationship with your lender. And if you don't have a great relationship with your lender, that you get your mail, right? But if you got a broken mailbox, you can't get along with your lender, bad things will generally happen. Try not to give forward-looking statements as legal advice, but I think I'm pretty safe with this one, okay? So the nature of the ownership, which deals with shares and leases, as opposed to having a deed, right, makes the relationship very different. Okay? And so it's a sort of a unique relationship. We have other cooperative corporations in other cities, but none like New York, because New York has mastered this concept of cooperative living, and we have a lot of case law where we have to balance the difficult rules of living with other people, which is also balanced by the business judgment rule, which is sort of enshrined in cases that deal with business corporation law. So get back into it. More differences between owning a unit as a condominium or as a homeowner as opposed to being a shareholder. Shareholders, they own a portion of the corporation. So you don't pay taxes on your individual unit. Instead, real estate taxes are levied on the property as a whole, and the corporation assesses the proprietary lessees according to their ownership shares. Okay? And so the cooperatives can encumber the premises with a mortgage, right? Which the shareholders then satisfy. There's a big blanket mortgage, right? But the individual shares themselves are held by the bank. They're held as collateral. This is very important. Right? So owning that collateral means you can then foreclose on it by simple auction under the Uniform Commercial Code. Very, very different. Right? So and what I mean by that is to take it a step farther, just as general information goes. It is very difficult to negotiate with a lender who is holding your shares as collateral. I would say it's about as similar to showing up to a knife fight with a banana. Even a very, very fresh one, okay? Because you're going to be at a severe disadvantage, right? And you're going to want to trust the attorney with his malpractice policy when you're talking for you, or at least do it in front of a judicial official. You may want to stay everything until you calm down and figure out what the real situation is. Okay? In entering into a proprietary lease with a cooperative, shareholders enter into a landlord-tenant relationship with a cooperative corporation. And that relationship is very similar to a conventional landlord-tenant relationship. It confers on the proprietary lessee some benefits that you would be owning. You could, in theory, bring a lawsuit to evict someone from your unit as the unit owner. Right? In a landlord-tenant case, all you have to do is prove that you're the shareholder, and the shares are in your name. And this roommate that you have, or some other person who is subletting to the apartment that you want them out. Right? And you have a voice in managing the building because you're a shareholder. And the shares to a unit may appreciate in value. And so, that share and leasehold interest, it can be leveraged. You can borrow against them, borrow to buy them. The proprietary lease establishes many of the rights and duties held by the cooperative and the proprietary lease lessee. The most important duty is proprietary's lessee's duty to pay the cooperative's maintenance charges, which is called rent. Typically, the proprietary lease provides an amount that may be amended in the directors depending on the building's needs. Cooperatives generally encumber the property as a whole with a mortgage, and real estate taxes are then levied on the entire corporation. And cooperatives depend on the shareholders to satisfy those obligations. Right? It is a closed system. There is no rich aunt or uncle hanging out to bail out these cooperatives. The chain is only as strong as its weakest link. And so that every shareholder is responsible for the upside and the downside of owning this cooperative. This is a very important concept to understand. When you have a litigious tenant, everybody will suffer because everyone will have to pay the attorney fees to an increased special assessment. Another thing to consider, which I don't have to get into so much, is that when we have priority of claims, the claim of a cooperative as far as maintenance is much higher than the claim of a lender to pay a loan secured by the shares. What does this mean? What it means is this. If you have an issue with your management company regarding some fee that you don't think you should be charged, and if you think that you're being unjustly charged and you have a dispute, once that money starts to get high, so for example, they say, I don't want to have to pay for this parking spot, I don't own a car, even though clearly the parking spot's included in the lease, I don't want to pay. The board has a couple of choices. One thing they can do is just battle out with you and drag you to court, but many times they're not going to do that. What they're going to do instead, the sneaky boards, from what I advise, they will write to your lender. Dear Mr. J.P. Morgan Chase, Sally Shareholder owes us $5,781 in unpaid maintenance. As you're aware, in the subrogation agreement, we have a right to all the proceeds of the sale of this unit if we have to take it to auction, because we may choose to just evict them or bring our own auction, which would mean that your recovery would then be limited by our priority claim. We are required to tell you this under the subrogation agreement, so you have the option of paying that money off. Now, meanwhile, Sally Shareholder is arguing with his management company who never responds to phone calls, doesn't put things in writing. And then they see that the next statement, it says that there's zero. They'll see that there's a credit of $5,781. Sally Shareholder will say, yes, that last email that I sent at 3 o'clock in the morning really, really convinced them. They came to the error of their ways. I'm the wrong person to mess with. A week later, they get a letter from J.P. Morgan Chase Bank, which says, we have advanced the sum of $5,781 to your cooperative because they requested it to us because they showed proof this money was already due and you did not dispute it. Therefore, your loan is going to be increased. You'll have to pay a higher amount of money to pay back the money that you owe us, and we will also start paying maintenance for you as an escrow. And our loan documents allow us to do this. Thanks for being our client. We look forward to working with you in the future. Feel free to to consult our private banking, and maybe we can start taking your auto insurance as well. Blah blah blah. Right? This is what they did, right? One-stop shop, right? So you call up Chase angry. Not you, of course not. You would never do that. Sally Shareholder calls up angry and says, "What's the meaning of this? I have this dispute. It has to do with the management company. It's got nothing to do with you and me." And then you start speaking with a customer service agent in Kansas City who doesn't know anything about New York law. But they can just say, generally speaking, if the cooperative sends us a bill and it's valid, we got to pay it. And if you don't pay it, we're going to be sending you this letter. This letter, which is just that one warning shot across the bow, right? It's the same warning shot that your grandparents, right when you start getting mad, they say, don't test me. Don't test me, right? If you're smart, your grandfather says that, your grandmother says that, don't test me, what's going to come quick is a quick strike, right? And then darkness. and then tears, and no dessert. Some people push and they push and they push, and then what happens is, then I got a phone call from the referral service saying, they're giving me auction my shares. And I say, no problem, I've done this before. I put on my fireman's hat, and I go down my pole to my lower suite, the downstairs suite, and I go out in my truck, and I stop the auction, right? For a modest fee. Right? But we don't want that to happen. And so it's always very important to understand, right? That when you get into a protracted dispute with your management corporation regarding this, they always have an ace in the sleeve. They don't need to deal with you anymore. Because if you're a headache, they don't have to bang heads with you. They can just go diagonally and go around you. And they will get the lender to pay. And then instead of them having to deal with a housing court case, or with a lot of cases get adjourned, and sometimes the judges won't ask you to consider the pay use and occupancy. They say, we don't want to hire Jimmy, to do a housing court case to get this tenant out. What we want to do instead is just call the lender and let them foreclose on it. And then I can get rid of this tenant. We don't have to deal with this nonsense anymore. We don't care, right? This is the problem. The chain is only as strong as its weakest link. Now, before I get into this, we're starting to get into another discussion regarding personalities, discussion, what makes up a cooperative, right? So, without getting too colloquial or anything like that, when you guys are taking a subway ride home, I want you to look around the faces in the subway car. Okay? Imagine the faces in the subway car and just see these people, random people. Jump to some assumptions about them. Doesn't matter. Look at the guy with the tattoo on his face. Maybe this guy's a shareholder in your building. He's going to be the one who drives your assessment up. A chain is only strong as its weakest link. Everyone is working together cooperatively. So when you're buying into a co-op, you're not just buying into a building, you're buying into the future of everybody together. What does that mean? That means if you have a cooperative and you have 3 people who own a television repair shop, financial problems in the future. Right? These are issues. If someone sneezes, the cooperative catches it. It's an issue. You're buying into things together, right? And the way that cooperatives counter this from everyone getting pneumonia all the time is that they approve people through the boards. Right? You guys may be familiar with this. We have the interviews that take place and questionnaires where we determine everyone's financial circumstances. This is why cooperatives are cheap, right? Because you can't use a lot of leverage. They want to make sure that you have money saved. They want to make sure that you have firm financial background. Right? Because in the city of New York, because of our human rights law, right, and various fair housing, you cannot discriminate against anybody according to their race, their gender, sexual orientation, creed, dietary habits. The way they dress, how to perfume they use, anything. And anything which appears to be superficial or just judging someone on their appearance or their habits, that's a big lawsuit, which the shareholder is going to pay for. But if you have poor credit, if you have cash flow, which is irregular employment, as a business judgment rule, the board can deny your application. And that's because they want everyone on a firm financial footing. Because if someone falls into a reversal of fortunes, everyone else has to carry the weight and pay a bigger assessment. Or the reserves of the corporation will go down. When the reserves of the corporation go down, it makes the units less desirable to sell. If there happens to be a foreclosure of the big mortgage on the cooperative, and there's not a lot of money in the reserves, that means that the loans for the shares will be wiped out. So 1, 2, 3, 5 dissident shareholders in a 60-unit building will make a lot of difference because the reserves will be lower. In order to counter this, because some people want to sell the units, right, that means that everyone has to pay an extra assessment. Now let's take this an even step further as we go off script here to speak about the 2 types of people who are in cooperatives. All right? The first type of people are sometimes young families who go into a cooperative because they want to be in a good school district. They need to have an elevator because, they need to put the carriages in there, right? They want to make sure that the railings are good and that the washing machine downstairs is working. They're concerned about the facade of the building being cracked because it may fall. And what they want to do is they want to make an investment in this cooperative and hope that it appreciates in value because the shares are allowed to appreciate. And even though there may be a flip tax, the idea is that you're going to use that as a starter home and get into it. You're going to buy a home or buy a condo unit. It's a place where you have your children through grade school. That's a stereotype of one buyer, right? Stereotype of the other buyer is a person who's on a fixed income. A person who worked their entire life and has their pension and their Social Security. For those people who are on pensions and Social Security, you're very aware of the paltry cost of living increases which have been going on in the recent years because the CPI, which is calculated by the government, is very, very, very low. Let's not get into the fact that it costs $11 to park 2 hours in Newtown. I mean, the government seems to think that we should only get a 2% increase on our cost of living, right? So you don't have no time for any assessments. You don't need time for any increases in maintenance. You're planning for things to be the same. The elevator breaks down a couple of times, big deal. Everyone should exercise more. Let's take the stairs. Parapets looks a little cracked, fine. We've been in the building for 30 years. No big deal. It's all cosmetic, right? But, things are okay. So what if the whole light downstairs in the laundry room goes out one at a time? Don't you kids have a little flashlight feature on your phone? Just use that. These are the two forces that are hitting each other in the co-ops every day, right? Which board do you have? This is the question. This is the question I ask in my initial consultation. You meet people to see where they are in their life. And usually what happens is you have one type of person in conflict with the other type of person. This is an issue. The chain is only as strong as the weakest link. So you may want certain things from your co-op, but they may want to do improvements. They may not want to keep things the same. This is where the problems come in, right? Now, for the second type of people, right? They're not so much interested in the sale value of their units because they want to be there until they die. Cool, totally fine. This is one of the wonderful things about home ownership in America. It's why it's called a mortgage, not a life gitch. You die, someone else's problem. See ya. Right? Great. Wonderful. No problem. I understand. As an attorney, having to deal with the aftermath of that, I'm grateful for that problem. It's cool. Right? Board members, management companies, other shareholders, they don't like that so much. Not so into that. They would prefer to reach into the grave and pull you out and say, oh, what about that assessment? But they can't so much. So they're going to get up from you before you dive into the unknown. That's what they're going to do. Right? And the same thing happens as well. When you have young people who want to sell their unit, but there's no reserves. Right? And then the people who've been there for a long time say, things are fine. But you just draw water from the well. You don't really have a well. Well, what about that rain barrel in the back? We can't do that, Can't do that. But this is the type that happens. These are your neighbors. You're all working together in a symbiotic relationship, right? And this is the problem with co-ops. This is why they're inexpensive, right? Because you're getting all that you're paying for, right? Not only these people are your neighbors, but you're all sureties for each other, right? And there's a lot of headache that you're dealing with. Yes. Yes. Right. So that's the framework of where we are with cooperatives. And I'm going to go a little farther with this and talk about some of the different types of these. We have low and middle housing cooperatives, which is from the state. We have housing development fund companies. This is where a city has taken over a building because of a tax foreclosure, some type of neglect, and instead of demolishing the building, they say to the owners, why don't you turn into a cooperative? We're going to set up some very low bono legal services and basically give you a sort of a package, articles of incorporation, and we'll give you some HUD funding, we'll give you some HPD funding, We'll allow you to fix the building up and you'll all be owners together. I have one of these buildings on the block behind my office. They lost the building, the owner lost the building in tax foreclosure, all the tenants went on rent straight, right? So they got the building, they were supposed to be moved forward and make it cooperative. And these tenants, as soon as they saw how much they were paying in maintenance, they were like, oh, it's fine. Fine, no big deal. We'll just climb up to our apartments and rope ladders instead of using the stairwell, which is fine. These are tenants who went on a strike for like 5 years. Then they own the building, they saw how much repairs, so they're like, no big deal. We'll just drink soda. We'll just bathe with sponge baths. No problem. These people are outside on the street all the time. I see them on the street because I know inside the apartment's probably falling apart and crazy. Right? God bless them. I love them, right? Because their kitchen that comes to me, I'll fix it. But that's a whole other, no big deal. Right? But this is the reality. You go from tenant to being co-owner, right? And so, these HFDCs are exempt from rent regulation because they're cooperatives and because they're nonprofit organizations. Okay. And because the government's sort of intertwined with these HDFCs, the tenants have to give the cooperative corporations have to give a lot more privileges than they would ordinarily get. So the tenants have a lot more latitude under these offering plans which are offered. And an HDFC tenant can't be evicted because it's expired. It can only be existed for cause. Right? So an HDFC is unable to evict a month-to-month tenant after issuing a 30-day notice of termination. We also have these hybrids, which are limited profit housing companies, Mitchell Lama Housing. They're called that because of the sponsoring legislators that they dedicate this to low or middle income housing under the public housing finance law. Private developers are eligible for government funding mortgages, tax abatements, and other incentives. That's the music to the ear of a real estate developer. In exchange for this, the housing projects have to limit their profits and rent increases and subject to DHCR regulation. The Mitchell Lama housing projects are required to submit financial information to DHCR, which then determines the allowable rent increase. So they can't just do it arbitrarily. They send in their operating costs, the cost of the fuel, the cost of the maintenance, and the DHCR looks over it to make sure the bill's not padded, to make sure they're submitting the entire thing, and then they can then say, this is what the increase is supposed to be. Before evicting a tenant for reasons other than not paying rent, they have to get a certificate of eviction from the New York Department of Housing Preservation and Development, this is HPD, for commencing a proceeding in the housing court. To appeal an HPD's determination of certificate of eviction, a party has to commence an Article 78 proceeding. An Article 78 proceeding means that when a litigant says that the decision of a governmental authority is arbitrary and capricious, it should be sent back to that administrative agency for review. Seen that be by the right, decision side. Party may not collaterally attack that determination in a Supreme Court ejectment action or summary housing court proceeding. We also have something about conducts, like they sort of talk about, they combine things with condominiums and co-ops. Yeah. So their buildings were divided into one large residential condominium or one or more commercial condominiums. The residential condominium is then transformed to a cooperative corporation. The cooperative corporation divides the residential condominium into separate units allocated to the proprietary leases. In other words, the cooperative owns the units under the condominium regime rather than owning the entire building. Right? So that's really sort of the only difference. Condos receive some tax advantages over the conventional cooperative. They can deduct their proportionate share of the cooperative mortgage, interest expenses, and real estate taxes if the cooperative derives 80% of its annual gross income from the shareholders. Separating the commercial space from the cooperative may allow shareholders to benefit from that tax treatment. There's also some other ways of tax stuff, but I'm not going to get into the tax aspects of it too much because I don't bring sheets. And this is ordinarily the time that you close your eyes and start thinking about living after dinner, so I'm going to skip over that. So, I want to speak for a minute about the veldt or the prairie where Jimmy Lalonde and Williams Gray, Housing Court. Right? Housing Court has jurisdiction over landlord-tenant disputes, including non-payment proceedings, holdover proceedings, which have to do with lease expirations or termination, lockout proceedings, Article 78 proceedings, where receiverships are set up for distressed buildings, and HP proceedings for code violations. Disputes between cooperative boards and proprietary leases appear in housing court because of the landlord-tenant relationship. No landlord-tenant relationship exists between a condominium association and its unit owners. They don't hear condominium non-payment and holdover disputes involving associations and unit owners. Cases involving cooperatives were part of the housing court's general docket until 1997, when the New York State Unified Court System created a separate part for cooperative and condominium cases. These proceedings involving units in cooperative and condominium buildings are heard in Co-op and Condo Part, which is obviously called Part C. And every borough has a separate co-op and condo part except for Staten Island, which hears all housing court proceedings under the blanket Part Y. Petitioner must identify the proceedings involving units in cooperative condominium proceedings. The housing court initiated the co-op and condo part in response to significant pressure from important real estate interests that want housing court to handle cooperative and condominium cases efficiently. Judge Leibowitz has posited in his treatise that the reason why they do this is because it allows these cases to escape an otherwise busy housing court document. And it allows and indeed compels the presiding judge to develop a special expertise in cooperative and condominium law. They have the warranty of habitability applies to them. The warranty of habitability regards to apartments requirements under several state and local requirements that they allow someone to reside in it without being comfortable. And the way I like to refer to this is I refer to this with the Whopper song. Well, maybe it was the Big Mac song, but it was like the big rage back in the late 80s and mid 70s. The song was, to wall beef patty, special sauce, lettuce, cheese, pickles, onions on a sesame seed bun. I know you know this. I see you guys nodding. I'm hungry too. Questions available. Okay. And what I mean by that is that we're all entitled to an apartment which is wind and water tight, which has hot water as a point of entry for electricity, an outer door which can block and unlock, right? Apartment which is free from rodents, all the things that would be included in the building code that an apartment owner is entitled to, right? So it guarantees that tenants that lease premises be fit for human habitation and for uses reasonably intended by the parties, and that the occupants of such premises shall not be subject to any conditions which would be dangerous, hazardous, or detrimental to their life, health, or safety. Any waiver violates public policy. Protection from lessees is effectuated through rent abatements when the court finds the premises conditions violates that warranty. Okay? Cooperative shareholders are cooperative owners, right? But represented by the board, the proprietary lease given to the tenant is not different from any other type of lease and creates a landlord-tenant relationship between the stockholder and the cooperative corporation. So the shareholders are entitled to a warranty of habitability. If the conditions in a tenant shareholder's unit are dangerous, hazardous, or detrimental to their life, health, or safety, that shareholder may be entitled to relief. Secondhand smoke infiltrating a leased unit has been found to violate the warranty of habitability. Excessive noise may lead to a warranty of habitability violation if the noise deprives the tenant of the essential functions that a residence is supposed to provide. So the warranty of habitability applies to the landlord-tenant relationship created in the co-op, but because of the cooperative's hybrid nature, the warranty applies slightly different. Now, if the conditions in the apartment is a direct result of a building-wide renovation project, the board of directors voted on and approved, it doesn't fall within the purview of the warranty of habitability. Then this special application allows the board to act with the entire building's best interest in mind, because the needs of the many outweigh the needs of the few, right? Because change is only as strong as its weakest link. Ultimately, the abatement court must look to the proprietary lease, determine whether the responsibility is to repair or maintain a condition that plausibly affects the warranty of habitability. What does that mean? That means that if people are suffering because of the fact that there's holes in the roof or there's a lot of construction, if it's for the roof, which is going to benefit everybody, the court's not going to view that as a violation of the warranty of habitability. If it's something cosmetic, or something that isn't really leading to the warranty of habitability, the court may find that the board voting on this affects it. But for the most part, a board which is advised by learned counsel, they'll understand the difference of it. Or they'll face my wrath. No landlord-tenant relationship exists between a condominium unit and a condominium association. It's not applicable. We also have HP proceedings, which you're allowed to do, where if you say there's a violation, it's not clear to you, like to call 311 and have an inspector for the building come out and put inspections on the unit. Right? And if the inspections aren't corrected within a period of time, these conditions, you can then compel the city on your behalf to bring an HP proceeding, which the city then tells the landlord, the petitioner, or the co-op board, if you don't fix this, we're going to fine the entire building, and if it's serious enough, we'll fix it ourselves and stick you with the bill. So, proprietary leases assign responsibility for repairs to the proprietary lessees if the problem arises within and remains within the subject apartment. And for the cooperative corporation, if the problem comes from outside the apartment. I'm going to say that one more time. Most proprietary leases assign responsibility for repairs if the problem arises from within the subject apartment, and to the cooperative corporation if the problem comes from outside the apartment. Where are the pipes in your apartment? The walls. Where are the walls? Who is that? The unit or the board? Whose responsibility is that? You would think that, but this is where attorneys' fortunes are made. This is where we get the big bucks, ladies and gentlemen, right? Because the board says, that's the lessee. And the lessee says, that's the board. And that's when I pull in my tie that doesn't have any mustard on it, and I start briefing and doing, right? This is why co-ops are not expensive. This is a refrain. I'm going to keep telling you guys this. So, housing court also has jurisdictions. So let's get to the real issue here, which is the business judgment rule. Right? This is the big issue with co-ops. Right? What happens with co-op? You get into a co-op, you buy into it in 1985, and you're living there for a long time with your family. Boards come and go. You don't really pay that much attention to it. But now you're older, and your kids have moved on, you're downsized, and the weather's not so good for you, and you want to leave, right? So you enter into a contract of sale, you get what you think is a good price. Person then goes before the board for an application, denied. And no reasons given. Find someone new, they say. Okay. But every time it rains, your knees are killing you. It's easier said than done. And you know that a union is not going for what the board says it is. What do you do? What do you do? The business judgment rule, which applies to cooperatives, prohibits judicial inquiry into actions of corporate directors taken in good faith and in the exercise of honest judgment in the lawful and legitimate furtherance of corporate purposes. Says Business Corporation Law, Section 717. Right, but the Business Corporation Law also applicable to cooperatives. It's a rule somewhat differently, saying the rule somewhat needs to have the directors to act in good faith and with that degree of care which an ordinarily prudent person in like position would use under similar circumstances. All right? Just one more time. That the business rule applies to directors to act in good faith and with a degree of care, which an ordinarily prudent person who wouldn't buy a co-op would in a like position would use under certain circumstances. Those situations, those four factors, right? Okay? Each of those things is the ringing of a cash register to an attorney's ears. Ka-ching, 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 ka-ching. It's great. All right? In the end, you just want to sell your unit. Why is the board acting like this? You know why the board's acting this. Because they don't like the food you cook on the weekends. They think that you overload the dryer because you got into an argument with them over their kid running around. It's petty, 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 petty. Right? You just want to sell and go away, but they're just putting that in you a little bit, right? Sometimes you read the newspaper, you read these angry letters to the editor. You're like, who are these people? Well, I'm the board. I'm the board. Except for the window. Oh, you got a lot of visitors coming in and out. Are you the FBI? You know? Come on. Chain is only as strong as the weakest link, and in their mind, you're the weak link, and they make it miserable. That's what you call your lawyer. But then acts like a real jerk. So much of this, hey, this person's not so bad after all, right? And you can tell the years of being a jerk has worked a lot of damage to my face. It used to be dumb. I have this mustache on all the time, but I take this weight on for all of you, and that's why I'm so expensive. A little lawyer humor there. Sorry. So, we developed this business judgment rule in the Court of Appeals. This is a very, very big case called Lewandowski versus 1 Fifth Avenue Apartment Corporation. And that they developed a rule to review corporate behavior judicially because a cooperative corporation, in fact, function is subject to the business corporation law, and the decisions of a cooperative board don't generally involve expertise beyond the usual kind of judiciary. But, it has to deal with people just living together. Right, so it's not like we're trying to figure out whether the board of Monsanto did the right thing by changing the generic makeup of Roundup materials, or whether or not it was a big judgment role for one corporation by another one. Is it fair for this business board to deny an applicant just because Susie Shareholder just cooked that really, really, really stinky food all the time and people really complain about it a lot? The average member of the judiciary can figure it out. Really can. It's not rocket science. In the Lewandowski case, a shareholder had sought to make alterations to his unit, including moving a steam riser. The shareholder's proprietary lease required him to get the cooperative's board consent before making any alteration. Right? Despite the shareholder's contention the alteration wouldn't harm the building's plumbing, the board, after consulting with an architect, said, "No, we're not going to let you do that." The parties eventually litigated the dispute with the shareholder, asking the court to overturn the board's refusal. This went to the Court of Appeals. So you have an idea. It went to the Supreme Court. It bounced around for a couple of years. Then it was appealed, and the appellate division bounced around for a couple of years. And then someone put on their shoes and socks and their tie that had no mustard on it and drove to Albany. And stood there in the cold, without the fine selection of restaurants that we have here in New York City, and said, "This isn't just." So they knew it was really unjust. Really unjust. If you've been to Albany, you know what I'm talking about. The court found that the board was acting within the procedures set forth in the proprietary lease. The shareholder was unable to show that the board didn't rely on its architect's advice or that any board member harbored any animosity against him. Couldn't show that there was an ulterior motive, right? Even if the shareholder had shown the building heating system would not be harmed, and the board's decision wasn't unreasonable, the court would not intervene, right? Because you bought into this, right? Right? So we have no fault divorce here now for many years. But, the court will say, not my thing, man. You don't like it? So. So, before getting into any more technical aspects of this, one motive to apply the business judgment rule to cooperative is to protect honestly made decisions from lengthy litigations. So, many courts which don't grant summary judgment motions, as long as people can prove, the board can prove that they do this because of the business rule and that this is the business judgment, they'll say sorry. Unless you can show emails, right, from the board saying, you're never gonna sell this building. We're gonna take it from you on auction. We're gonna drive you out. We're gonna take your livestock and feast on it while your children cry out in hunger. Like, unless you get a tape that says that, you're gonna have a hard time. This is why co-ops are not expensive, right? Because they're easy to get into and hard to get out of. Right? Roach motels. Remember those? Remember those old commercials? Bugs come in, they don't come out. I'm not trying to say you're a bug. I'm just saying. You gotta know what you're dealing with here, right? It's like walking into a nightclub going, wow, this music's loud. Yeah, this is where you're at. Courts have also been quick to grant summary judgments when there's clearly within the board's authority. Resident challenge rules of prohibiting delivery of food by placing the food packages of the elevator and sharing the elevator to the shareholders' floors. So this guy didn't want that rule saying, look, I don't want to see this guy. I just want to have my food put in the elevator and then just send it up. I watched that television show. What was that one? Different Strokes, right? And Mr. Drummond, the guy who adopted Arnold Willis, I thought about would you think he was cool if you knew that he stiffed the delivery guy so much until he could buy that apartment on Park Avenue? Here you had this Mr. Drummond who was like, I don't want to see the delivery guy. I want to give him a tip. Have him put the money in the thing and just go up and I want to take the food. The board's like, no, we're not going to do that. You have to go down and step the guy to his face. And the guy took it to court. No, I'm going to pay an attorney instead of tipping the delivery guy. The court said, sorry, dude, you're out of luck. This New York, what can I tell you? What are you going to do? Courts have also challenged summary judgment against enforcing cooperative rules. The defendant's membership in a club which shareholders use summer colleges was terminated due to rule violations. Because they were unable to show that the board singled them out or treated them differently than they did it for other people. The court just said, look, it's the business judgment rule, that's the rule. You don't have any proof that they're singling you out. Maybe they do like those things you're cooking on Sunday. You can't prove it. This is a problem. This is what I tell my clients. You got videotape, you got emails from me, you got letters. You don't. They always look at me weird when I go to the laundry room. Okay, I don't tell you. Maybe you don't like your 10 cats. I don't know. Right? Nothing wrong with having 10 cats. If we have 10 cats, probably shouldn't live at a co-op. That's just me. Okay? It's not really legal advice, it's more life advice, so I can give that kind of not a big a deal. Business judgment rule may shield some cooperative boards from litigation, but won't shield actions taken in conflict with contracts. Where there's an alteration agreement with a resident, and then they just decided to change their mind because they just said we're just going to just break it. You can't do that. If you entered the deal, you can do that. So a bigger problem is objectionable conduct. And they can revoke those things for objectionable conduct if you're doing objectionable things. It applies when the business judgment rules require when they challenge shareholders, challenge lease terminations. As long as the shareholder can't show there was bad faith, they're going to say it was rationally related. It's a big problem. There was a Pullman case. It's called Pullman, when some shareholder circulated flyers throughout the building accusing one longtime resident of being a psychopath, right? Alleging his wife had intimate relations with the board president and had cut his telephone wire. Wow. The problem shareholder performed renovations in his apartment without the board's consent and on weekends. In accordance with the proprietary lease, the cooperative board convened with a proper notice. They had a special meeting. What are we going to do about Bob? What about Bob? Remember that movie, What About Bob, with Bill Murray? What are we going to do about Bob? Bob's sending out these flyers. He's working in the apartment. He's claiming someone cut the line on his phone. I think it's time Bob's got to go. Right? So they said, listen, if you can't show any animus, it's perfectly reasonable to suggest that someone has to leave if you're circulating flyers saying that the wife is stepping out on the guy. I don't know what to tell you, Went to Albany, too. I don't think this guy had counsel. If he put on the shoe himself and said, hey, and his tinfoil hat and said, it's not right! And they cut my phone lines! They were just like, nope, sorry. They always say the decision reserved, so no one's crying on the train ride back from Albany to New York. It just take a while to figure it out. It's better get them get them a few counties away before they decide to say no to it. It's good. They're smart up there. Right? So I'm seeing reaching like 7-11. I'm probably going to get into more questions, and I want to just mention a little bit about the Martin Acts, okay? Because I'm going to give you, if you stick around here long enough, I'm going to give you that little tidbit, which is going to really, really aid you in your dispute with your condominium here in Brooklyn if you are renting from the sponsor. Okay, so let's talk about the Martin Act. The Martin Act offers the offering for sale of the condominium and cooperative units. There is an offering plan which is given, right? It's an offering plan which contains a lot of disclosures regarding the rights and regulations of people who are buying these shares, because it's like a stock sale. It's like you're buying into a corporation. You have a right to know certain things about a cooperative. What its financial health is. You want to see its cash flow. You want to see its balance sheet. And you want to see how much it has in reserve. You have an opportunity to see what the budgets are. So you can make a rational decision as to what you think your expenses are going to be if you're a shareholder there. If you see that the oil thing is going up and up and up, you may rationally understand that maybe your assessments will go up. And as a practitioner in transactional work, when I have a co-op sale, my co-op and condo rider, which is written by the real estate board of the real estate committee of the co-ops and condominium board of the New York State Bar Association, the property section, of which we've had an opportunity to discuss comments. And when it's being written, I look at them and I engage in discussion, albeit slightly, right? The contract says very straightforward. If you are buying a co-op in this unit, when you give us this money as a down payment in your contract, if they decide to jack up that rate of $500 more maintenance, there's nothing you can do about it because you can do it at any time. You can't back out of the contract. At any time, the co-op board, if it's not a regulated board, from a low income, a middle income, or a neutral llama, if they in their business judgment rules say there needs to be an assessment needs to go up, that's it. I had a case where I have clients who own a condominium unit. They went ahead and they looked at minutes, and after they bought it, a few months later, they got a notification that they had decided they were going to replace the roof at a cost of maybe like $160,000, and we had to pay an extra $20,000 as their share of the cost in order to get that roof on. They retained me to sue the board and the attorney who represented them, and the judge said, happen at any time. I'll tell you, it's their problem. My clients had to stop the litigation because it's too expensive for them. They got shorted $20,000 out of it. We made $750,000 in the sale, so it wasn't all of it. Anyway, don't cry for them, they're fine. So, in any event, the Martin Act is applied in this way. We have what's called eviction plans and non-eviction plans, right? And, if a sponsor seeks to convert a building from rental units to condominium or cooperative units, you either have to do an eviction plan or a non-eviction plan. A non-eviction plan will be not deemed effective until written purchase agreements have been executed and delivered for at least 15% of all dwelling units. As bona fide tenants in occupancy, the bona fide purchasers who represent that they or one more members of their immediate family intend to occupy the unit when it becomes vacant. A non-eviction plan is called because sponsors may not commit eviction proceedings against non-purchasing tenants with failure to purchase or any reason applicable with expiration of tenancy. Right? So non-purchasing tenants subject to rent regulation for an operating plan is filed continue to enjoy regulations after filing. The Martin Act protects free market non-purchasing tenants from unconscionable rentals for comparable apartments during the period of their occupancy, which has been interpreted by the Appellate Division's Second Department as prohibiting landlords from demanding above-market rents from non-purchasing tenants. This protection is not a form of rent regulation and does not prevent large rent increases consistent with market conditions. What does this mean? What it means for one of my clients is that his father, who had been employed by the cooperative board, began hanging out with a bunch of dissonant shareholders who didn't like the way the board was acting. So they tried to do a coup and got rid of the board, and they failed, and my client's father got evicted. Not evicted, they got fired. And my client owned, my client was a tenant in an apartment which was owned by the sponsor. And the sponsor then sent him a notice saying they're increasing his rent to $1,000 a month. In Brooklyn. So what does Jimmy do? Shimmies down that firehouse pole. On my hat. Woo! Ran to the courthouse. Said this has got to be stopped. And the landlord's attorney, when he saw the lawsuit, said to the board, "What are you doing? Jimmy's right. Can't do this. Got to shut this down right now. Stop it. Let's get all his attorney's fees." So went to court and said, "They did the wrong thing." You know what the landlord's attorney said? "You're right. They're wrong. That's it. You gave them a new renewal lease, including $100. Our bad. Sorry." This is like thousands of dollars later. Right? Thousands of dollars later, this poor kid had to pay me. Which I thought that, the board was going to pay, but they figured out real quickly. Jimmy's right. My bad. Moot. Supreme Court says, "Look, it's moot. You got what you want. What do you want from me, Jimmy? I got 50 motions here. You're going, I said to my client, "Well, take it to Albany." My client said, "No, fair enough." So this is the thing, in the first department, which is Manhattan, Westchester, Bronx, that they say, no, it doesn't apply. But here, they can't terminate a lease for any reason, and it can only be reasonable increases with market rents. They can't bump it up $1,000. When I spoke to one of my maidens in the co-op, the condo board, whose name will remain anonymous, he said, "What do you know about that case in the second apartment?" We found out, huh? It's a big secret. So now you guys know, if you're renting from a sponsor in a non-eviction building, they can't just terminate you. You may get a notice in the mail, you may get a petition. Talk to an attorney. Who knows? It could be bluffing. This guy was. So I'm going to go real quickly into this. This comes from online. Before you buy a co-op or a condo, the physical aspects. When purchasing a unit in a co-op or condominium, most consumers focus on location, size, amenities, and price, but equally important is analysis of the physical aspects of the property. This is true for newly constructed buildings. You got to get an engineer, probably, not just an inspector. Okay. The New York State Office of Attorney General has promulgated regulations, right? And it says that the prospective purchaser reads the entire offering plan and consult with an attorney before signing the purchase agreement. Very important. Before, right? Purchase of a unit in a cooperative and condominium has many significant legal and financial consequences. Prospective purchasers consider the risks associated with purchasing a unit in a cooperative or condominium. New construction, that the text of the offering plan regarding the size and construction of the building, units and ancillary spaces, parking spaces, rooftop cabanas, they all have to be in the offering plan. Selling agents frequently make grandiose statements about ancillary spaces or amenities in the unit that, if not specifically promised in the offering plan, are not required to be delivered and probably will not. This comes from the Attorney General from the website saying, don't believe the guy who owns a nicer car than you, okay? The car's nicer than you and they're saying, you got the rooftop cabana. Be careful. Talk to the attorney with a junky car. Okay? All buyers have to read the description of a property section in the offering plan to determine the sponsor's obligations and should not rely on advertising brochures, verbal statements from selling agents, or beautiful pictures of artist rendering. That's awesome. What to look for in the offering plan? Recreational facilities. The Attorney General regulations require the facilities be described in detail, and the offering plan includes 4 buildings of recreational buildings. A description of the equipment to be installed, and details regarding size and materials to be used in the construction of such things, such as pools, tennis courts. Landscaping. The regulations require landscaping to be disclosed in detail, including things as the number and type of trees to be planted, the approximate number of bushes, whether the grass will be sod or seeded topsoil, whether there will be an underground watering system, etc. However, in most developments, sponsor installed minimal but adequate landscaping, and when purchasers want to upgrade the siding, they must pay for it themselves. Appliances and amenities within units. The Attorney General requires that the offering plan consists of the brand name, the types and model numbers of appliances to be installed, which gives the buyer information on the quality of the appliances, whether the home will contain other amenities such as a fireplace or a jacuzzi. Keep in mind that if the item is not promised in the offering plan, the sponsor is not obligated to provide it and probably will not, except at substantially higher prices. Offering plans frequently state the sponsor can substitute equal or better appliances, but not appliances of lesser quality. The facade. Low-rise homes will have various kinds of siding, including wood, vinyl, or brick. Many larger buildings in urban areas have facades made of materials such as brick, cement, or exterior insulation finishing system, which is called EIFS. Purchasers may wish to consult with an architect or engineer to understand the differences between facade materials. Purchasers will review the offering plan to determine whether sponsors provide any form of warranty. Right? And but the most difficult task for a buyer is to get a general sense of the quality of the construction of the development. Is the building using top quality wood? Or are they constructing a second-rate manner? Without incurring the expense of hiring a professional to read the offering plan or inspect the property, a buyer can easily do some simple, common sense investigating. For example, the offering plan will state the manufacturer and model number of the window to be installed. A phone call to the window supplier listed in the telephone directory can reveal to the buyer whether the windows are top quality or merely serviceable. I mean, this is very nice information to have, okay? But, you know, when I was representing buyers in 2006 and 2007, when anyone was getting a loan, people would call me, and I had like a list of questions I would go through. I didn't really represent a lot of buyers, mainly because the questions were very hard hitting. The first question was, okay, so what's the purchase price? X. Okay, what's the home heating costs? What? I'm like, you know, when it gets cold, how much does the oil cost? That's included? Yeah, you find out. That's it. Never heard from that person again. Right? In New York, if you speak a different language, the language is something native, and you get installed into an installment contract, that's for a waterbed, exercise bike, or whatever. Let's say Russian is your native language. The Department of Consumer Affairs requires that that contract be in Russian. Yeah, that's right. Okay? But you can buy a $2 million condo without speaking a lick of English, and no one cares. Because in New York, you can do certain things. You can urinate on the mayor's shoes while he is dedicating a new subway platform. They won't take you to jail, they just give you a ticket. But the minute you mess with commercial property in New York State, they will shoot you in the face like a terrorist and throw your body in the water so your family can set up a grave. It's the straw that stirs the drink. So therefore, buyer beware, especially with these real estate transactions. Because what they're going to say is, what was your attorney doing? That guy paid him $60 and 2 popsicles. He was sleeping in the car the whole time. He said I knew what I was talking about. He said I had good grasp English. He didn't even find him anymore. I saw him selling carpet on the street the other day. Now, if you use the lawyer referral service or reputable source, it's highly unlikely that will happen. Highly unlikely, right? So these are the things you got to be aware of, right? They'll let you, once you start getting into real estate, you know, they're going to start saying, well, what was your attorney doing? Right? So the big problem that you have with co-ops and condominiums, right, is that it's blind real estate. The biggest problem that we have here in America really is that there's not a lot of price flexibility on a lot of things, especially in New York State where we have things like title insurance, premiums are regulated by the state, right? So, you know, the mortgage rates are usually at prevailing interest based on whatever your score is. You're not really going to be able to do much regarding some of the other things, but, you know, the one thing that you can always hit someone with is your attorney fee. Consequently, there's a race to the bottom. There are a lot of attorneys who offer lower transaction costs. You know, every little bit counts, but sometimes you hire these attorneys and you're speaking to the secretary, and the attorney's going to come wandering in, couple of hot dogs in each hand. Sorry, I was going between closing, just sign it, looks fine. This is a problem, you gotta be really careful, use something better. All right, I now have a whole whopping 4 minutes to answer for questions. Make them good, please. I'm quite tired, I need to eat. Wow me, yes?
If you are purchasing a property, on a co-op, and can you hold a board for capital needs assessment plan?
The question is, if you were buying a co-op, can you hold the board to their,
Like if something happens after you.
if something happens, can you hold them to the capital assessment plan that they had disclosed previously before? Well, the answer to that is going to be this. And what's going to say in all the documents as well as going to say, these projections are forward-facing and are subject to change according to market disruptions. And we reserve the right to change them if they do. So although you may enter into it with the expectation that things are going to be the same, for example, if there's a change in the price of natural gas, right? Or there happens to be something you're having to do with financing, those things can radically change. So it's going to say, we intend to do this, but, we intend to do a lot of things. I intended to go to Yale. They didn't want me. That's a problem. Anyone else remember? Yes, the lady in the middle.
Hi, if you are a shareholder in a co-op and there are non-paying shareholders in the engagement, and the board is collecting this kind of monthly on a quarterly basis, do they still distribute that delinquency throughout the entire building to the other shareholders, and then you as a shareholder have the right to the details of the non-paying shareholders, like what's the delinquency, how long has it been going on, that sort of thing?
Okay, so the question was, if you have a delinquent shareholder who's entering into a payment plan to make up the delinquency, it's still proper for the other shareholders to understand how much they're paying to make up this delinquency and to understand where it's being apportioned to. Are you going to get a breakdown for this? Most of the time what happens is if you appear at a board meeting and the people taking minutes, you can raise those issues. Because the board has a fiduciary relationship to act as the behest of their shareholders. But you have to understand too, the other issue that they have is, of course, not all shareholders want to have the board running with a huge reserve, right? The deeper issue has to be is that some shareholders want to be running as lean as possible, and other shareholders want there to be deeper reserves, because the deeper reserve is, the more attractive it is for financing. There's always going to be that interplay. So although you may request those things at board meetings, and you may make an issue of it, they're not really under a lot of obligation to show that it's proportioned fairly. It's just the issue needs to be is that you want to make sure there's not preferential treatment. And what I mean by that is this. If a vice chairman of the board has another unit that he uses to store his old video game cartridges for ColecoVision and Sega Genesis, and it's empty, and there's a constant balance running from that, and they let it slide by him paying $50 a month towards it, but yet they're throwing out the senior citizens because they have a small short charge, that's really an issue. And that's why you say, hey, how come Jerry gets to ride on his stuff, but we all have to pay for everyone else's, right? This is when you start getting into, challenging the board, elections, you get into derivative actions, come see me or another attorney from the lawyer referral service, and start stacking that cheddar, and then we start getting our briefs ready. That's what we do. And there's another question? Yes, it's the lady in the blue.
Can the board legally set a price for your unit? And is there a set number of apartments you can pay?
Yeah. So the question is, can the board set a price for the unit, and can there be issues where is there a set number that can be owned? The second question, ownership usually depends on what your financial ability is, and if the board makes a business judgment that you have a financial ability to own shares, then that generally works. Now, whether or not the board can set a price for that or not, that has to do a lot with price fixing. And so what ordinarily has to happen is the subjective nature of cooperative units, and we have to do what's known as financing. And when you're dealing with a crazy, you're dealing with what we call comps, units of comparable similar value, right? So if you're coming and the problem is that because real estate is so individual and it's so specific to everybody, it's perfectly reasonable for you to come with one set of comps saying, the building next to us supports this price, and the other people saying, no, there are other comps in other areas which are less. And the real deep issue of this has to be with this. When you want to sell, you don't really care so much that you're leaving money on the table. You need to get out. Your aunt is ill in North Carolina. You got to get there. Your kid needs to pay for next year of college. You don't want to be in this co-op anymore with that family with that kid that's screaming all the time. So you're ready to sell, and you don't care if you need $20,000, $30,000, $40,000 on the table. But the board, which is obsessed with this phantom equity, right? This phantom equity, which is this horrible concept which is pushed on us as Americans, right? As though it exists, right? They're like, no, I can't let a unit that's of this comparable size sell for less because that means mine is less. But it also means that people who are looking to buy into that will know that they have something over you because of that. You say, why am I going to sell this unit for $250,000 when Sally's shareholder sold hers for $220,000 and that was the only unit that's selling? I'm going to take $220,000. So the board knows that when you want to get a fire sale prices and just sell to get out, they're not going to let you, right? Because this is why co-ops are inexpensive. Because of this. This is the problem. Any other questions?
So the answer is yes.
Yes. The answer to the question is that you have a rational way of saying that this is what it is, but it's extremely subjective. They have a rational business, and they can find it. They have a rational business rule to show that their valuation is better than yours, and that you're undervaluing it, you're going to be stuck.
Okay, but let me just ask you a
Follow-up question.
Yes. So you take that example, you have the phantom equity that you obviously sell.
Yes.
Yet, like the lady was saying back there, you have all these units that are empty, that are running empty.
Okay. So what generally happens is that there's supposed to be a portion among the shareholders in equal value. So that means that the sponsor has those units that are empty. The sponsor then has to give their proportionate share. So whether they're empty or whether they're full, it really doesn't matter because everyone's based on not just a proportion of occupied shares, it's supposed to be everyone's shares together. So if the sponsor or somebody's keeping them empty, they have to pay that share anyway. So at the end of the day, they have an incentive also to, just as you do, to keep the cost down because if they own a bunch of units, they have to pay for that. So this is the issue, right? So, yes.
Under Mitchell-Lama.
Yes.
Okay, I see you're pretty well versed with that.
Appreciate that.
Okay, some Mitchell-Lamas are cooperatives and some are rentals.
Yes.
Our understanding is if you are in a rental Mitchell-Lama, it has to be run by a nonprofit urban development company, correct?
Yes, under the Mitchell, they have to follow these certain things because there's that interplay between. Oh, sorry. The question was, if you're living in a Mitchell, does have to be run by a nonprofit organization?
No, the rentals.
The rentals. Okay.
The rentals.
Okay. So the issue is that although the co-op itself, right, has to be nonprofit, right? Mitchell-Lamas are free to sometimes use managing agents, right? Which get paid for their services. So technically speaking, they can get money, but the end result is that the money is not going into some sponsor's pocket. So it's supposed to be, so they have a higher standard because it's intertwined with getting government tax breaks, often government subsidized mortgages for that, right? So, and also because it's all under review of DHCR. So the issue is, even if you wanted to gouge a tenant, DHCR has to review, and they're going to say, why is this management company getting a $20,000 a month fee in order just to manage this building? They would never let that stand. So everything is super, super lean in these Mitchell-Lamas.
I didn't finish my question.
Yes, what's the question?
My question basically was, who makes that determination as to who is a cooperative and who is a rental? Because what we found out in my particular development before it opened, there were 518,000 shares. When the development opened, it reduced down to 3 shares. No one knows where the other shares went. And it was split between the 3 owners. And they started running us as a rental. So my question is, were they allowed to do that under Mitchell-Lama law, just change it from a cooperative to a rental and split those shares? Because I'm assuming that the owners now own blocks of apartments split between those 3 owners. And we're treated as the tenant, and they're the sponsor, I guess.
Okay, so the question is a very involved question regarding a unit that started off as Mitchell-Lama and then was then somehow converted from a nonprofit into a profit with 3 shareholders, which would involve an extremely lengthy, look and view of the documents as how that happened, where there would be several agencies who would have written up this. There's many pieces of this magic eye puzzle which needs to be fit in before we give you an answer on that. But it sounds fascinating. Yes. A co-op can enter into an agreement for can agree, enter into an agreement with a cable company if it's rationally related to the general maintenance of the building. And what I mean by that is this, right? If there's something prohibited that would not permit DirecTV to put their dishes which have to face east, such as another facade, or the fact that there are other things, or if the cable company can offer them a discount for providing those services, and there's a rational business rule that would permit everyone to do that, then yes, they can do that. But it can't be arbitrary. There needs to be some reason behind it. You know, and these just has to do with every issues as well. Everything has to have a rational business rule to it. That means there has to be some type of discussion, that type of thing.
And one more question.
Yes. One more question. You did good. You're on.
But you spoke a lot about how co-op are personal property, but it's also the case, is it not, that you can, that a buyer can get a mortgage and deduct the interest on the mortgage just as if it were real estate.
That is correct. The judge raises a very important point that you have an opportunity then to treat that mortgage deduction from that co-op as though you were owning real estate. And most of the time, in tax law, they're permitted to do that. Only in limited circumstances will you can. Right? And then you be well advised to speak to your accountants regarding your makeup of your co-op, whether or not you're permitted to do that or not. So always talk to your tax professional. Because I'm not qualified to be LRS taxes.
No, you are not.
Thank you very much for coming.
Thank you, and the ladies' room is on the third floor, the men's room is on the second floor. Someone was at the back to direct people as needed. But please come to all of our programs, and again, please spread the word. Thank you. Thank you.